Good morning, my friends. My name is Cheryl Spengler, and welcome to Life in Northern Virginia and the Good Side of Real Estate. If you check out my YouTube channel, The Good Side of Real Estate, I'm doing a lot of explanations of topics like today, which is me ranting about the legalities of evicting a tenant. This is really causing a problem to landlords and tenants, actually, but what landlords don't realize is that tenants know the law more than the landlord. The landlords, people renting out their homes, they really never look into what rights they have or don't have and what rights their tenant truly does have, because things have changed in the state of Virginia. If you're listening to this and you own a home and you have 3 or less homes that you own and rent out, everything I say applies to you. If you have 4 or more homes, you are held to kind of a different standard. And one of those is that if you own 4 or more homes in Virginia, you're legally required to get your homes qualified for a housing choice voucher renter. You cannot simply create a tenant selection document, which if you don't know what that is, I'll try to link it to this podcast. A tenant selection document is something that you basically create as a landlord with a standard, and the standards can't be anything about personality or how many children they have or whatever. It's a standards of reasons of your high standards that you are choosing to require every tenant to adhere by in order to rent your property. Tenant selection document is how you keep certain people out of your property. I mean, like, their credit has to be a certain number. You can say you can, never have a bankruptcy or in the last 5 to 10 years. You can make all these criteria really mostly around finances. And if they don't meet that criteria, then you can say no. But they have to, I'm diverting, but you have to first create a tenant selection document. I'll link it here. And then you have to make everyone sign it prior to them stepping foot into the property. And then that they've signed it. So typically, if 100 people inquire about the place you have for rent, don't worry, we're going to get to how to evict them. If 100 people inquire about how to rent your property, and you send them all a tenant selection document asking them to sign it, that is their acknowledgement that they've read all the items on the list and that they have, they qualify. And so if later they still apply, and I would recommend using a program like rentspree.com or whatever, somewhere where they have to pay their own background check and credit check. Normally it's $39 they have to pay with a credit card. They're giving permission for you to pull their credit, background check, eviction notices, stuff like that. And when they do get that pulled, then inside the software rentspree.com, for example, you can deny them based on the reasons given in RentSpree, the legal reasons given for anyone to be denied. And one of those reasons is the word other. And other would be tenant does not meet the tenant selection document requirements. So it's important to create that separate from just let me have them apply. How do I decide who rents my property? I can't discriminate. That is true. But you can create a higher standard document that everyone has to adhere to and sign and read prior to entering the property. That way, if they do apply and they don't meet those requirements that are listed out in writing, then you can deny them. And so let's say you get someone in your property and you are having trouble collecting rent. There's a few reasons why you can evict someone. First of all, I'm not looking at a website right now to read them specifically, but basically if you have said that there's not to be any drugs and you find out there's drugs, if they're damaging the property, if they, obviously the biggest reason is that they're late on their rent. And if they're late on their rent, damaging the property or doing something illegal, you have the right to evict in the state of Virginia. So let's say they're late. Here's my recommendation, and I'm not just being a hardcore bitch, okay? I'm being realistic. On the 31st day that you have not received your rent, that means that they are 30 days late. You send them either through hand delivery, which means you have to take a picture of you giving it to them, or by certified mail or delivered by sheriff, okay? This is on the 31st day they're late. This is not you. You send them a 5-day pay or quit notice. That says you have 5 days to pay your rent that is back due, plus whatever the lease says is a late payment, or I will start the eviction process. Then you have to wait 5 days, and then you go down to the sheriff, and for $12, you file an unlawful detainer to evict. That is basically step 2. Step 1 is 5-day pay or quit, delivered. Step 2 is file unlawful detainer for $12. I'm going to walk through this whole process, then I'm going to go back and talk about it. When you do the $12 unlawful detainer, you are physically going down to your courthouse and you are filing at the counter an unlawful detainer document stating that the tenant is late. You've already delivered a 5-day pay or quit and have not received your money. Then they basically take that filled out document and you get a copy, and then they give it to the sheriff, and the sheriff delivers a notice. Well, at the time it's processed, there's a court date assigned within 30 days or less. And that document is then delivered by the sheriff to the tenant and a copy to you that states the court date that you and the tenant need to show up to. It's normally like 2 weeks out. Then you show up. And if during that 2 weeks you got all your money, then you still show up and you say, oh, I got my money. And if not, then you show up. If the tenant doesn't show up and you do show up, then the judge has... Technically, they'll either go in your favor as to moving forward with the eviction, or they'll say, let's postpone and give the tenant another opportunity to show up. And let's just say they don't show up. The tenant still has 10 days to appeal, okay, whether they show up or not. If they don't show up and the judge says, we're not going to just wait out the 10-day appeal. We're going to go ahead and postpone and give them another opportunity to show up. Then you got to wait for another court date. And let's just say they don't show up to the second court date. Then they have a 10 days to appeal. At the end of the 10 days, then you file a writ of eviction. And that is the second official legal document. And it's done there at the courthouse. And then in that case, after the writ of eviction document, there's 72 hours that goes by after that's filed that the sheriff then contacts the tenant and coordinates them to get out, or they will physically have their stuff removed, and the landlord will have the right to change the locks and coordinate a time they can get their stuff out. So in that whole process I just told you, where most landlords go wrong is that they wait and wait and wait to do that first unlawful detainer document. They send a 5-day pay or quit in regular mail and they don't keep a receipt. Then they send a 30-day late, then they send a 60-day late, then they send a 90-day late. And you're just like thinking, these are officially sending documents to tell them they're late. But the tenant already knows, okay? Tenants who are late, the first thing they do is they get on Google, okay? Landlords, they don't get on Google until they realize all their work is not working. Sending random letters in the mail, return receipt or not, is not evicting your tenant. It is simply delaying the process of eviction. The only single document that you need to send, sorry tenants if you're listening to this, but landlords really got to get informed here. The only document that you need is a 5-day pay or quit. You wait the 5 days, and on the 6th day, you go down to the sheriff's office and you file an unlawful detainer, period. Because otherwise, nothing legally starts. When you file the unlawful detainer, like I said, you get a court date assigned. The tenant has the right, whether they're late and not paying, destroying your property or anything. They have the right to stay in the property until that court date. So you can say, I'm evicting my tenant and they're not getting out, and I've given them notice and they're not getting out. You're not doing anything until you have filed an unlawful detainer. And in that unlawful detainer document, you are given a court date. That court date is the only legal date that tenant has to wait for a decision to be made. And then even after the court date or on the court date, starts a 10-day appeal time frame. So technically they have until the court date plus 10 days. And then at the end of the 10 days, then the sheriff gets a writ of eviction document. And then 72 hours later, they're basically physically coordinated a time when they are removed. So it's not a waiting game, okay? You don't have to wait. It can be done in 50 days, okay? Typically, so the biggest problem is that landlords are too easy. They know they got a family, they have kids. Every single sob story known to man is given. You feel bad. You feel like a terrible person. Like you don't want to put someone out on the street. No one wants to put anyone out on the street. However, tenants know the laws more than the landlords. So landlords are going bankrupt themselves, having to file bankruptcy themselves, unable to pay bills and buy food for their family. Literally, it is causing financial distress on the side of the landlord, their home environment. Even if you're wanting to sell a property that someone's not paying rent for, you still have to evict them. I mean, you can't just kick them out and say, I'm selling. I have this situation right now, trying to sell a home. A tenant kept saying he was letting people in. We thought agents that were getting in. Turns out he was locking the door and not letting people in. So hadn't paid rent for 8 months, but the landlord never filed an unlawful detainer. So you can say all you want, email all you want, text and send letters all you want. But unless you do that first unlawful detainer document and get a court date, the tenant has the right to stay in the home. And you actually could have a lawsuit against you if you physically remove them or kick them out or anything. They have a lease. And the only way to remove anyone with a lease is through the court date. So I hope this is somewhat informative for anyone dealing with this situation. And if you're a tenant, I already know that you know your laws, but you're destroying, the finances of the landlord, but you don't care because you're trying to stay there and live there as long as possible until the last possible second that you're kicked out. But for landlords, I think people need to wake up and just, if you're going to choose to buy a property and rent it out, adhere to this law to the fullest extent, because otherwise you're just going to make your life miserable. And if you have any questions, I recently answered a ton of questions on my YouTube channel to a gentleman who inquired, who doesn't even live in Virginia, but he was asking questions about how does he evict a Section 8 tenant. And there is two differences if you're planning to evict someone, regular tenant or a Section 8 tenant. The two differences are a regular tenant, they're late, it's the 31st day, you give them a 5-day pay or quit, you wait 5 days, you file an unlawful detainer. Section 8, they're 31 days, 30 days late, you do a 5-day pay or quit notice, and then instead of immediately going, if they don't pay, to file unlawful detainer, you actually have to contact the Housing Choice Voucher Program, and you have to give 10 additional days after the 5-day pay or quit has passed for the Housing Choice Voucher representative to come sit with you and the tenant and discuss why they're late, if they're going to continue to be late, and how they can pay up on their money. If in that 10 days, when you sit down with the Housing Choice Voucher person and discuss the late payments, it's determined that they can't pay and they're still not paying, or they've done something illegal or destroyed the property, then you can move forward with the eviction in the normal way, which is go down to the courthouse and do unlawful detainer. The process is exactly the same. The only difference is you have to contact the Housing Choice Program and coordinate a 10-day time frame, and you have to give 10 days to sit down and discuss with the tenant. Now, if there's no discussion and that just doesn't happen, then you have to still allow that 10 days. And the Housing Choice Voucher Program manager has to contact the tenant, because obviously they're paying half of their rent, 3/4 of their rent typically, so they will respond. And there has to be a discussion. That's the only difference. In between the 5-day pay or quit and the filing an unlawful detainer, you have a 10-day period where you have to sit down and try to negotiate. Otherwise, it's the same exact process. And then when the lease has ended, and I'm just talking about Section 8 here, but if the lease has ended with a Section 8 tenant, or let's say for whatever reason it is terminated, or they are evicted, or they get divorced, or someone passes away, then that housing program contract is ended. And then you have a choice as a landlord at that point to create a new tenant selection document that says, I will not be moving forward with anything with a Section 8 voucher tenant. If you have 3 properties or less, you have the choice when the lease is over to create a new tenant selection document stating you no longer are accepting Section 8 tenants. So hopefully that answers a lot of questions about evictions. And I don't know if you have any questions, maybe drop a comment. Check out my YouTube channel. It's called Good Side of Real Estate. And I'll talk to you guys in the next podcast.